recording the PowerPoints out to everyone, hopefully later today, but if not, we will do so tomorrow. And just to let everyone know, your phone lines are going to be muted throughout the webinar. If you have any questions, please type them into the questions box, and we will then relay those questions at the conclusion of the webinar to Maureen. And with that, let me introduce Maureen. She is located out in Sacramento, California. She focuses her practice on providing strategic public policy, litigation, and regulatory advocacy and counsel to a wide range of product manufacturers, brand owners, industrial facilities, and landowners. She represents clients in enforcement, defense, and regulatory compliance issues before administrative agencies in Sacramento and numerous state capitals, and provides international permit and compliance counsel on environmental, product, and supply chain regulation issues. With laws governing corporate social responsibility on the rise, Maureen assists clients in developing their corporate policies to meet sustainability, chemical, supply chain transparency, anti-slavery and human trafficking, conflict minerals, and related statutes. Ms. Gorson is the former director of the California Department of Toxic Substance Control, where she directed soil and water cleanups under CERCLA, RCRA, water and brownfield laws, and the regulation of solid and hazardous waste, as well as spearheaded the California Green Chemistry Initiative and the new laws governing toxics in products sold in California. Ms. Gorson is the former general counsel of the California Environmental Protection Agency, where she oversaw the enforcement policies and activities of the myriad state, regional, and local agencies that enforce California's environmental laws. She is also the former general counsel for the California Natural Resources Agency. With that, thank you very much, Maureen, for being here today, and I turn it over to you.
Okay, well, thank you very much for that introduction, and for everyone on the phone for spending this next, I don't know, 40 to 50 minutes with us while we talk about the new California Safer Consumer Products regulations. So what happened was in 2008, the California legislature passed a law, and it said that DTSC, the Department of Toxic Substances Control, which is part of the California Environmental Protection Agency, was supposed to set into place something that would stimulate green chemistry and an innovative economy. They were supposed to identify data requirements and quality and test methods and develop an online toxic clearinghouse so that everyone would have the same baseline information as the government on different chemicals and their toxicity. They were supposed to identify and prioritize chemicals of concern. They were supposed to develop science-based alternative assessment tools so that it would be very easy for industry to kind of pluck this information and these tools off the website to help them design products that are safer and greener and use greener chemistries. Unfortunately, they didn't do any of that. This is kind of like a little diagram, but from 2008, when I was director, till 2 directors later and 5 years of rulemaking, this thing really went south. I'm not going to go through every horrible thing that's happened since 2008, but they made 8 different attempts to draft the regulations, all of which met with 100% industry opposition. It's very rare to see regulations to become final without even a single industry group or a select companies supporting the regulation. But they were not able to do anything that made any sense to anyone, but they continued forth and they adopted the regulations August 28th of this year, and the regulations became effective October 1st. So despite a very sordid history, they are here to stay with us now. So what's happening now? All right, they became effective October 1st. Right before then, they finally published the initial chemical list. If you can, you should go on their website and look at the candidate lists so that you can figure out if any of the materials you make or sell are on the list. By April 1st, 2014, and now they're saying they may do this as early as January, they're going to pick an initial set of products. They're saying between 3 to 5. They could pick more than 5 and then narrow it down, that are going to be targeted to go through these regulations. Now, the number one question I get asked all the time is, what do we think those products are going to be? And we don't have any clue. So unfortunately, we're all just waiting with bated breath to see what they pick. They're going to go through a rulemaking process once they pick these 5 products. And after the rulemaking process, you know, with all the notice and comment periods, and they'll do economic analysis and environmental analysis and all the things that are in a traditional Administrative Procedures Act process, they're going to pick the final list. And that will start the commencement of all of regulatory responsibilities that people will have under these rules. So once that final priority product list is done, which the earliest would be April 1st, 2015, within 60 days, everyone in the supply chain making that product, selling it into California, will have notice requirements. Within 180 days, some entity within that supply chain will have been designated to do a preliminary AA report, and within 1 year, the final AA report. The AA report is the Alternatives Analysis Report. In addition to kind of this first set, this initial priority product list process for the first 5 products, by October 1st, 2014, they should identify all of the products that they intend to focus on in the next 3 years. So we think that will be between 18 and 15 product types. And just because a lot of people ask this, we're not exactly clear on what they're going to define as the product, so to speak. Whether it's going to be a finished assembled product, whether it's going to be a component of a product, whether it's going to be a material in a component of a product. So we don't know how narrow or wide it's going to be. We do know that whenever they pick, whether it's a product or a component or a submaterial of a component, that it's going to be for every product in that product type. So for instance, if they selected nail polish, it'll be for every tube of nail polish sold in California, not just for some nail polish and not other nail polish. In addition to this picking the priority product activity that triggers all of the regulatory requirements, they also have a generic data gathering authority in these regs, and we're expecting those kinds of queries to be coming out in early 2014. Any manufacturer could be asked to provide existing data, generate new data, or even be required to do additional testing on the toxicity characteristics of its products and materials that it uses in products sold in California. So they have not started implementing this authority, but they have it. So the first thing they had to do was select the chemicals on the list. So what they've done is they've looked at all the existing lists around the world, and they've just basically come up with a list of lists. And for the first 3 years, this first round, the initial candidate list is about 248. And I say about because when I go on their website, it started at 330, and then it was 303, and they appear to be refining it as they realize there are errors on their list. So you do have to keep checking with their website because they are making a lot of adjustments as people identify problems with how they've compiled their list. But right now, that initial candidate list is about 248, and those are the chemicals that they could choose in the first 3 years. So a priority product containing one of those 248 could be selected to go through the regulatory process. Beyond 2016, for all additional rounds when they select priority products, they have a full candidate list of over 2,000 chemicals on it, and they want that to have a flexible palette. Anyone can petition to add or subtract to that list. And the risk-based criteria of the initial list, meaning the first round list of 248 has to exhibit both exposure hazard, be on exposure lists as well as hazard trait lists. After 2016, it will only be the hazard traits of the chemicals that will be part of the selection process. So how are products selected? This is an even more mysterious process than how chemicals are selected because they have wide open flexibility. Right here, I've kind of said what the most popular guesses as to what they will choose are, and these guesses are just based on things that they have said in public, the staff. What they have right now in the department are profiles, product profiles. So they have some sort of process they're going through where they're identifying products and chemicals, and I don't know, it's like a deck of cards. They're going to pick 5 of these cards and select them. And then again, October 1st, they're going to pick more products. They think 8 to 15 in the first 3 years, but up to 185 products could get selected in the first 10 years of the program's implementation. So if you get selected and you're listed, you have 60 days to provide notices, 180 days to provide a preliminary alternatives assessment report, 12 months to provide a final alternatives assessment report. There are 2 extensions possible. 24 months looks like a pretty easy extension again, and the 36-month extension would be only if your product then had to go get approved by another agency for safety in order to be sold. Then you would get a 3rd year. And then the regulatory responses, they could last forever. So who has to perform this? They are not supply chain. They're going to hold everybody liable until one of these people steps up and supplies the notice for all of them. It's a very poor regulatory design because you've got millions and millions of products. They're going to select to go through this horrible paperwork tunnel that could last a very, very long time. And after you provide all of this data and analysis to them, it is extremely unclear what they're going to do with it. There's very little criteria for how they're going to select regulatory responses based on all this data and analysis you provide them. It is not a nice, well-lit tunnel. It is a murky, scary tunnel with tons of unknowns in it. There are a few safe harbors. You can remove your product from California Commerce. You just say, I'm not going to sell this product in California anymore. You submit your product removal notification, and then you don't have to go through this scary, murky regulatory process. The retailer may cease ordering the product, and they can submit a cease ordering notice to DTSC if they don't think that somebody up the supply chain is going to be coming to the table with all the data and analysis. Regulatory duplication is a safe harbor, but it's very, very narrow because you can only get out of this if what the basis for the listing of your product and the selection of your product is the same as some impact that is addressed by another regulatory program. So say VOCs under CARB regulations. So that'll be very narrow. And de minimis is another very narrow, meaning my product contains this material, but it's such a low level that it's below the practical quantitation limit. So very few ways to get out of there. If your product is selected, you have 1 to 4 notices that you may have to submit in the first 60 days. Either you submit the priority product notification that says, yes, I'm selling a product, it contains this chemical of concern, and I'm in this regulatory process now. Or you send in the, I'm below the threshold, I'm below the de minimis, and therefore I'm out of this regulatory obligation. Or you submit your product removal notice or a chemical removal notice saying, I'm taking the chemical out of the product, or I'm removing the product from commerce in California. After you do that, you still have to submit a confirmation notification to them saying that you did the thing you were going to do in the first notice. So a tremendous flurry of notifications that will happen in the first 60 days. Once you're in, you haven't been able to figure a way to get out, you will have 180 days from the date of the listing of the priority product to prepare the preliminary alternatives assessment report. And then 12 to 24 months after DTSC approves your preliminary alternatives assessment report to complete the final alternatives assessment. So here's the first stage of the alternatives analysis, the preliminary AA report. There's 6 steps that you have to have in this preliminary AA report. So step 1, identifying the product requirements. You have to explain why the chemical is in the product. What function does it serve? What performance characteristic does it give the product? Is there a legal requirement that has to be met for that ingredient? Then you have to determine whether it's necessary. Now, this is not part of the statute. This is definitely a specific twist of the philosophy of the current director of DTSC, who believes that if a chemical is not necessary to perform a function in a product, it should not be there. So this has got the fragrance industry absolutely apoplectic, because many products have a fragrance, but the fragrance is not necessary for the product to perform its function. And a lot of phthalates and like d-limonene and other ingredients that are in fragrances have been mentioned when the department talks about this. So this is a very concerning aspect of this first report. Then if you determine that the chemical of concern is not necessary to meet the product's requirements, you have to consider removal of that chemical without a chemical replacement. They do offer you an exit here, meaning you can get out of it. If you can say, all right, I'm taking the chemical out, it's not necessary for this cleaning product to have a fragrance, we're taking it out, and therefore we can get out of this regulatory process. Second step in the preliminary A report is to identify all alternatives. This is a very concerning part of this as well, because they want you to cast the net wide. And even though industry in that 5-6 years of rulemaking begged and pleaded for the word feasible to be put into this, meaning you only have to consider feasible alternatives, they rejected that instead and used the words possibly viable alternatives. And in addition to anything possibly viable, you have to include any alternatives that are posted on the department's website, meaning people are going to suggest things to them and they're going to list them on their website, and then you're going to have to consider these alternatives regardless of their source, their feasibility, or any realistic aspect that's a viable alternative. If you consider any identified alternative, you can explain why it's not viable, but it's not clear what are the criteria for that. So this whole thing is going to be treacherous when people get into it, because you have to think about not just replacement chemicals, but different materials, different product designs that would have obviated the need for that chemical. Step 3, you need to identify all the relevant comparison factors. So you're going to have to identify all the factors that can make a material contribution where there's a material difference between how you're making your product now with the existing chemical of concern versus how you could make your product under one of all of these different alternatives. I know somebody did a little exercise and they found there were over 1,000 factors, because you have to look at not just the differences, in the product itself, but for all exposure pathways across all life cycle segments of making that product, from raw material extraction to manufacture to transportation to use by the consumer to ultimately disposal of that product. And among the other factors that you have to include in this comparison is the estimated volumes of the chemical of concern for the product and each alternative that will enter the stream of commerce in California. And a lot of people have said they're not going to know how to do that at all. Step 4, initial screening of alternative replacement chemicals. You will have to look at where you're looking at a chemical-to-chemical substitution in your alternatives analysis. You will have to compare each alternative chemical, their environmental fate, their physical chemical hazards, the physical chemical properties, and any adverse public health impacts, again, across the entire life cycle of that product. And the only alternatives that you can eliminate at this juncture are those that would pose a greater impact on the environment or public health, equal or greater. You cannot reject alternatives at this phase that are infeasible, like that would not meet customer expectations for performance of the product, or that just cost-wise are economically infeasible, or technically, there's no technical way to actually make the product in that way at this juncture. You're not allowed to eliminate those alternatives at this point in the stage. Then they allow for consideration of other factors. They don't really tell you what those are, but they kind of give you this kind of open-ended area where you can try to explain away as much as you can to try to narrow the focus of this alternatives analysis. Because the few people who have done an exercise trying to actually do this alternatives analysis have said just trying to narrow the scope and focus to something that is workable and can actually lead to decisions on product design or chemical choice is going to be a real challenge given how open-ended the requirements are in this alternatives analysis. And then finally, and realize this is the first 180 days. All of this has to be done in the first 6 months after you're listed as a priority product. You have to develop a work plan and a proposed implementation schedule for your full final alternatives analysis. And this is just some of the content requirements of the preliminary AA report. You have to have an executive summary. You have to show who prepared this, names of all the parties involved in funding and directing and overseeing and reviewing it, all information on your supply chain, including all purchasers of your product in the prior 12 months in California, all locations of all retail sales outlets in California, information about how, it's like I said, we don't really know how they're going to define the product, whether they're going to define the product as the whole product, a component of the product, a material in the component. But if they pick, say, a material and a component of a product, you will have to identify all the products, the brand names that that component is sold into. And then you have to include a scope of all of your relevant comparison factors and alternatives. DTSC will have 60 days to review this preliminary AA report and decide whether or not it has any deficiencies. You can have deficiencies twice before you get placed on the failure to comply list. And a lot of people are concerned about this because it's very open-ended. There's very little criteria in the regulations to know when DTSC will find what you've prepared in your preliminary AA report as satisfactory and complete. So people are concerned about that. And then your preliminary report will be posted on the website for comments of the public in California, including NGOs and plaintiffs' lawyers. Now we're in the second stage of the alternatives analysis. Once you get DTSC approval of your preliminary AA report, you will have 12 months to 24 months, whatever schedule you work out with them, to complete the final AA. And I'm not going to go through everything that's in the final AA. It's just like the preliminary AA, except in more detail. And this is, what you're going to have to do is now you're really going to have to put the quantitative analysis into how are you comparing your product to all the alternatives, where are you getting your information from, how are you weighting, and what criteria are you using to decide that making a product one way versus another way is safe or not. And then you in the AA have to make the selection decision of which is the safest way to make your product. I mean, I find it hard to believe that anyone's going to pick anything except the status quo as the safest way to make their product, because how are they going to say in this that they could have made it safer but they didn't without exposing themselves to all sorts of product liability and toxic tort lawsuits? So it remains to be seen what these things are going to look like. And then you prepare your final report. This is all of the elements, they call them the life cycle analysis elements that have to be considered in this final report. And you have to do this across, again, the entire life cycle of the priority product and the alternative. So it's quite a lot of analysis that has to be done. I think important to mention is that what they're looking for is not a risk assessment. Traditionally, products go through risk assessment. If it's safe enough, then it's okay. This is more of a comparative chemical hazard assessment. Just says, is there something safer? Which is safer? It's not whether the product you make now is safe. Was there a way to make it safer than you made it right now? Green screen, and I just throw this up because they were supposed to, in the statute, come up with tools that made it easy and clear for industry to figure out how DTSC is going to judge these things. This tool is not that clear, but it's probably the best one out there, and it seems to be the one favored by the department right now. So it's a third-party group that's come up with this green screen tool, and you might want to become familiar with it and understand their rating and criteria system, because I believe that the DTSC is going to use this when they're making their determinations as to what is safer, regardless of what you've put in your AA. Just quickly, EU REACH focuses on chemicals and the toxicity hazard traits of those chemicals. This is really focused on product design and the life cycle impacts from that product design. Compare it quickly to Prop 65, which a lot of people are familiar with. Prop 65 is only concerned with two hazard traits: carcinogens and reproductive toxins. This reg has 40+ hazard traits, including aquatic toxicity, endocrine disruption. I'm going to post the hazard traits. Prop 65, if you have a product that contains a carcinogen or a reproductive toxin, there's only one regulatory response, which is to slap a label on the product. Under these regs, there's many, many regulatory responses. DTSC could ban the product. They could ban the sale of the chemical. They could require and mandate substitution to a different chemical. They could mandate extended producer responsibility requirements on the product seller. If there was no safer alternative, they could require you to fund R&D and allow you to continue to sell your existing product. They can also have place of sale restrictions and other label restrictions on where you sell it, who you sell it to, under what conditions you sell it in California. The one good little bright spot is that whereas Prop 65 has citizen suit provisions, the Safer Consumer Product regs do not, which means that bounty hunting plaintiffs' attorneys are not going to be seeking to enforce this. They can only petition DTSC to require a regulatory response. So you won't be in court, but you will be in a regulatory agency. Here are all the hazard traits that you will have to analyze for your chemical of concern, as well as any replacement chemicals. And you can see it's a lot more than carcinogens and reproductive toxins. And after you get through this process and you've done this alternatives analysis, this is what DTSC can do based on that analysis. They could say, okay, you're done, thank you, you're making a safe product. They could say, you know what, we need more data. They can, restrict your product, require labels. Now, one nice thing is that they will not select the regulatory outcome until they go through a public comment period. So at least, as mysterious as the selection process is going to be, at least at the end, there will be some transparency and an opportunity to say, that's not the right one, you should have picked a different one, and there'll be an ability to have some input at that point. Trade secrets are a big issue. You know, who's going to decide? There's a lot of information that they're requiring be disclosed in these alternatives analyses that are confidential business information, and they seem to have a little greater protection in the regs for those that are patented versus those that are trade secret. And so this is something that I think a company that gets selected as a priority product is going to have to evaluate whether they are protecting that information in the way best suited for this regulation. If DTSC does not agree, you know, what you'll do is when you submit your information, you will submit a redacted copy and say, this is all trade secret information. They'll have an unredacted copy, and if they say, you know what, we don't agree with you, and we're going to post on the website the unredacted version of these materials, you have only 30 days to go to court to get an injunction from them doing that, which is not much time. So what should you be doing now? I think you need to pay attention to this initial list of chemicals, know whether you are making a product that, or selling a chemical into products into California, what kind of data you have on them, whether they're a safer substitute. You should pay attention to the priority product selection, because there will be an ability to try to get yourself deselected in this initial rulemaking process to say this. We're being selected inappropriately. We're not, you know, causing major harm in California. This is a waste of societal resources to put us through this process. And in the end, we're just going to keep making this product the way we make it. So there's no green chemistry innovation that could possibly emanate from this process. I think you want to think about, if you get selected in the initial priority product list, who in your supply chain is going to be actually complying with the regs, and what happens if somebody in your supply chain gets scared. You know, what if the retailer just says, hey, I don't want to have anything to do with any products on this list, and they just stop inventorying your product in California. So you want to take a look at your supply chain contracts to make sure you can protect your inventory, protect your options for reformulation, and make sure that your chemical or material does not get deselected from upstream manufacturers. And you want to know who's going to supply the notice, who's going to perform the AA, have an idea of whether a consortia should be developed to do it, who's going to perform the toxicity testing, who's going to supply the data, and whether there'll be a compensation scheme amongst the parties. And of course, to take care of your antitrust, anti-competitive concerns, because they're going to pick the priority product across all companies. So everyone selling that product is going to be in the same boat. So there's quite a few antitrust issues that are presented. I think you want to, once you're selected, look at your trade secret status, make sure that you have evaluated and have the processes in place that, because you really only have 30 days to go to court to get an injunction, that you can go right to court, say, I meet all the requirements for protection of a trade secret, here's all the evidence, have it all lined up so that the judge agrees with you and enjoins DTSC from disclosing that information on their website. Because you're not going to be able to develop that information in that 30-day time period. You really have to have that done in advance. And then you should think about customer communications, because once you're posted on these lists, DTSC is, and the NGOs that are kind of supporting DTSC, they're going to have press. They're going to, you know, say these are the products and this is why we're concerned. They're going to be justifying why they've selected these products and why they need to go through this regulatory scrutiny. And you're going to need a good customer communication, because your customers upstream are going to say, hey, how come you're on this list? The public will be asking, media will be asking. and you have to think about how you're going to discuss the fact that you're keeping some information trade secreted during the public review process of your product's design. So that's kind of the overview. That's quite a bit, and I'm happy to go back over any of the slides in more detail or answer any questions anybody has.
Thank you very much, Maureen, for that great presentation. If folks have questions, please go ahead and type those in, and we will relay those to Maureen. The first question we have up is just kind of a general question that I can answer. Yes, we will be sending out the slides hopefully later today or tomorrow, so you guys will get those. The next question up for Maureen is, what are the chances that that these regulations move and get taken up by other states or even nationally?
Well, certainly other states are looking at this. Washington, Maine, Oregon. Oregon is going to have a bill, I know, that would try to create a similar program in Oregon in January. I know a lot of people are concerned about that. And, you know, all of these state agencies are coordinating with each other through the IC2, the Interstate Chemicals Clearinghouse Group, and they are sort of divvying up responsibilities amongst themselves. So, for instance, California was supposed to put a template for what does an AA look like, right? Right now, an AA is just include all of this information in your AA, but it doesn't really tell you how to put it together. And meanwhile, state of Washington got a grant from EPA to put out an AA guidance document on its views on how an AA should be prepared. So you have this sort of outsourcing of California's regulatory role to the state of Washington, funded by EPA, with the 12 or 15 or so states that are active in this chemical ingredient consumer product regulation area. So I think you're going to see these states coordinating, and each of them trying to do what they can to flesh these kinds of rules out, so that they can, to the extent possible, create a national program.
Okay, great. The next question up. What is DTSC?
Department of Toxic Substances Control, and it is a department of 1,200 employees, a $200 million annual budget that is a part of the California Environmental Protection Agency. And the California Environmental Protection Agency is 5,000 employees, $2 billion annual budget. So it's a giant regulatory agency in California that, before this statute in 2008, had mostly been responsible for implementation of RCRA and CERCLA, so that's contaminated properties in California, and getting them cleaned up. So this is their first foray into regulating products. They've had a couple of little forays. They, had mercury thermometers and perchlorate in airbags and lead in toys, but this is their first really big foray into regulating products. So they're taking all of their experience in regulating contaminated properties under CERCLA and RCRA and now applying it to products sold in California.
Okay. Next question, and again, if you have any questions, please do type them into the questions box. Are silica sands on the initial list of chemicals?
I believe so. I have not looked at that specifically on the initial 248. They're definitely on the larger list, because anything that's on the Prop 65 list is on the list, and I believe crystalline silica is on the Prop 65 list. But I haven't looked at whether they're on the initial 248, but they're definitely on the larger list.
And with that, it looks like here's another question that just came in. California has recycled carpet market used in new finished product. Will finished product be part of this AA if recycled carpet source has listed chemical additives, and will it be the new manufacturer's responsibility to make the AA?
Yeah, that's a good question. Certainly, during the development of the rules, the recycling industry said you have to treat contaminants differently than intentionally added chemicals, because when you have recycled content in new finished products, there are contaminants going along for the ride. They're not part of the design of the product, and DTSC has refused to really exempt contaminants in that way. So who is going to have the responsibility is going to be dependent on how they define the product. If they define it as the finished product, the carpet, and then that product manufacturer and everyone in their supply chain is going to have the duty. But if they define the product as this component going into the finished product, then it will be the component manufacturer, the person manufacturing the recycled material, that will have the responsibility. So until they define what is the priority product, whether it's a component, a raw material, the finished product, we don't know.
Okay. Well, with that, it does look like we have answered all the questions that have come in. So I would like to once again thank Maureen for doing this webinar. All of her contact information is on that last slide there. And I will be getting the PowerPoint slides out to everyone hopefully later today. So thank you very much, Maureen, for putting on this webinar for us, and thank everyone for attending.
Well, thank you very much. Feel free to call or email if you have any questions.
Perfect. Thank you very much.